Good afternoon, everybody. This is Omar Serrano with the Tilted Lawyer podcast. I'm joined by my friend Lauren Knighty, who is out and still
Okay.
probably jet lagged over there in Australia. We have breaking news. Well,
I mean, it's 5 in the morning here, so I don't know what I
I
am.
have no sympathy with you. For you, no children.
I'm gonna tell your wife you said that.
Oh, I tell her all the time. It's like you did this to me.
Okay, but we're gonna gang up on you is what's gonna happen. So
Yeah. So you broke the news earlier today about the 12b6 motions being granted in favor of Lively, where most of Justin Baldoni's complaint was dismissed. And I know a lot of people are in a state of mourning, but I'm trying to urge everybody to kind of take a deep breath and let's think about this critically. Does this mean that Justin Baldoni can't defend himself? No, it doesn't mean that at all. Interestingly, I have read the entire 132 page, that's what I was doing earlier, 132 page motion. I'm going to have to read it again because it is loaded with reasons and case law and statutes. But I'll tell you what, a lot of the things that I was bringing up that I thought were going to be issues for Justin way back at the beginning of the year regarding his repeated acquiescence to Lively in her demands and constantly giving in to her demands and constantly reaffirming her with, oh, you're such a brilliant person. We're so lucky to have you. And then constantly just making concessions all the way through the production of the film to post-production to the advertising of the film was going to be problematic for his complaint.
Mhm.
And the reasons why this complaint was large, well, let's be clear. There are two surviving causes of action, and only two related to the tortious interference and breach of contract stuff. The defamation and the fraud is out. Does that mean that he still can't allege that as a defense? No, he can still say and use whatever facts he has to defend himself at trial against Lively. It just means he can't recover for those causes of action. And maybe that's a good thing, maybe it's not. My main concern was whether or not this was going to implicate 47.1 treble damages. And whether or not that's going to happen is still up in the air. Lively has to renew that motion, as I imagine they are going to renew that motion and probably forthwith. Lively is going to have to make a case showing that her complaint is privilege, invocating 47.1 and treble damages, and we'll see. Right now, it's dismissed without prejudice. They're going to re-litigate it and all. I will go through some of this complaint with you, although not 132 pages. I did read it in its entirety in half of the footnotes. I couldn't read them all because Lauren was yelling at me. And
yelling at you.
You literally text me, "Hey, I had a bad dream about you. What the fuck, dude?" Like
that was yesterday.
Oh, was that last? I just read it this morning.
It was yesterday.
Well, let me go ahead.
Before you kind of get into this, I feel like people are really obviously upset right now. A lot of people have been like super invested in this and like are not happy about. And of course, like I understand not being happy about it, and I understand why people are upset, and they're like kind of pointing to different reasons why this might have happened. People are going to call me insane, but I just want to say that I know all this has been kind of thrown out in regards to like the $400 million lawsuit. I don't think that that is ultimately his priority. I think that somehow, and I know that this is why I'm saying people are going to say I'm insane. I think that somehow this is all going to still work out in the kind of aspects of what's most important to him, which is going to be his reputation and his family's reputation. And I mean, obviously, this isn't something that anybody's going to be happy about, but I really do have faith that this is still going to go in his way as far as public opinion on his reputation and all that, because this is like far from over in that aspect. So
Oh, it's not at all over. I mean, if
right.
anything, it's just beginning. Look,
Yeah, but there's a lot of mainstream outlets with the clickbait headlines right now that are making it
yeah,
sound like he's lost everything, and I don't think that's true.
the lawsuit stuff is still up in the air.
Right.
The tortious interference is not just throwaway cause of action. He can still be awarded hundreds of millions of dollars potentially by securing victory on that cause of action. And that one is significantly easier to plead than defamation and fraud. And look, I talked about the 12b6 motions. We had to stretch to find a way to connect the dots. Now, a lot of what I was saying, and I think a lot of what other people were saying is, yeah, and even Friedman said it, that our complaints may not have been artfully pled, but we feel that all of the elements are there. They had an opportunity very early on to move and request to amend the complaint. The judge kind of clued them in and say, you keep on saying about how deficient your complaints are. So I'm not going to grant you an extension for this discovery. I'm not going to grant you an extension for your deadline to request amendment. If you think you should do it, then it seems like you already know. Do it now. And they made a business decision or a strategic decision not to do that. Basically, trusting in their oppositions to the 12b6. And that was a risk. It was a risk, and it was surprising to me. I think it was surprising to a lot of lawyers, but they did it. I'm not going to be the guy to like criticize the strategic maneuverings of Brian Friedman, but that was a head scratcher, especially with the judge kind of hinting at the fact that, look, it looks like your complaints are deficient. And it wasn't just me. It was a lot of other attorneys. Asked two lawyers said it looks like they're trying to tell the Wayfair parties that they got some work. I was left with the impression that they would have moved to amend, but hey, they showed confidence in their pleadings, and this is the end result. It happens.
What's going on with your PDF here, man? You can see like half the page.
Oh, did I zoom in too much?
That was worse. Okay, there you go.
Yeah, I'm just gonna hit some of the highlights. Alexandra Ison with a 5 says, can they bring in new evidence claims? Oh yeah, of course they can. That's kind of the whole point of the amendment, is to bring in new evidence if they have it, to structure the arguments. Like one of the things as far as the breach of contract claims, the court said, look, I can't make a ruling on whether or not amending the complaint will be futile if I don't know what the contract is. So you guys told me it'd be no problem amending the complaint as to that portion of it, so do it then. So yeah, they could bring in new evidence, they can bring in new facts, but they can't do it with respect to defamation and fraud. Those are out, and they are out forever. So let's get into some of that stuff. I guess, look, if you are supporting Justin Baldoni, as I know many of you are, you have to be prepared in litigation of this magnitude that you're going to have losses. And some of these things are going to feel bad, and you're going to feel deflated, and you're going to feel like you lost the case. But look, there's a long way between now and March of next year. And he is not dead in the water from defending himself. He can defend himself however he thinks he needs to with respect to the sexual harassment claims and the smear campaign claims against him. What he can't do is recover on a defamation cause of action and a fraud cause of action. That's all. He can't recover money under those specific causes of action. He can still recover attorney fees and costs if he's victorious for having to defend himself. He can still recover damages under the surviving causes of action. So it's important to just realize he's not dead in the water. He's just a little bit handicapped. And maybe some of the pressure is relieved because we have some clarity on the fraud and the defamation, and we're not going to continue to keep jumping through hoops to try to prove. I think the key that the judge, what he signaled in on, it seems to me, is how are you going to show malice? How are you going to show civil extortion? Which tangible benefit? And then they're going to say, okay, you're going to argue the PGA. credits. Well, I have no way of determining whether or not that's even a valuable thing. And furthermore, it appears that, I mean, I'm not going to like paraphrase, but he's basically stating that you guys didn't prove to me that malice was a thing. And he goes on and he
Sure.
restates what the law is. Malice is a lot more than you have ill will towards this person. It means that you had a reckless disregard for the truth. And you guys couldn't even plead to me that he was recklessly disregarding any truth. For all he knew, on the information that he was given, he had a good faith basis for believing that he was an SP. And you haven't shown anything in your pleadings to suggest otherwise, which means that his opinion is First Amendment protected. That's what the lively parties were arguing, and the judge kind of agreed. And one thing we know about this judge is that he's very he's very much sticking to the letter of the law. You have to show it to him like he's 5 years old. He's not going to do any kind of mental gymnastics that will support your position. That's your job. And he explicitly states that in this ruling. He says, look, I'm not going to sort through these convoluted 225 page pleadings to find viable causes of action for each defendant. That's your job, to make it nice and simple and concise, whatever. He says some of those things. So he said a lot of things. Let's get into some of it. I don't know how much of this you read on your earlier live.
Probably maybe, I don't know. I skimmed over a lot of this beginning part, but probably maybe half, and then I did end up, going through the rest of it off in between these. So
okay,
that doesn't mean it made more sense to me, but it I did go over it.
Well, so I'll tell you what, it's going to take me like another read to fully digest everything. I just kind of skimmed it because it was 132 pages. I need to get through it in an hour. I have to prep for this with you. So, they start off with a background and stuff and, introduction of the parties, and Wayfarer Party's amended complaint contains allegations and stuff, and 12B6 motions were filed, and the court has considered several documents which are deemed to be part of the amended complaint. He goes on to make a statement about how Exhibit A, although 168 pages long and largely in support of the motion, is not by itself considered a part of the complaint for obvious reasons. It has to be concisely stated and such. So you can't use that to form the basis of a prima facie case, is what he meant by that. That's kind of what he's describing here. Under this standard, the amended complaint is deemed to include the New York Times article that is the subject of the Wayfarer Party's defamation claims, the accompanying video, Lively's CRD, a list of 17 protections demanded by Lively to return to production, and emails between the New York Times and Wayfarer Parties. Each of these documents is extensively quoted and discussed in the amended complaint. And then we move on. In determining whether the Wayfarer Parties have stated a claim for relief, the court does not consider Exhibit A to the Wayfarer Parties' amended complaint. A defendant is entitled to know the allegations against it and have those allegations framed in separate paragraphs with sufficient clarity to allow the defendant to frame a responsive pleading. In other words, you can't just say, oh yeah, he defamed me, and look at this 200-page exhibit full of like 1,000 text messages. You got to make it plain and simple what it is you're on about. They list some cases. He goes on to explain Exhibit A is a timeline providing a summarized account of the sequence of key events, which is an additional 168 pages long. It is significantly, but not entirely repetitive of the amended complaint, but it does not set out its claims in numbered paragraphs as required by Federal Rule 10. Document is not a written instrument that evidences legal rights or duties or otherwise forms the basis for the Wayfarer Party's claims. Before I get into this, Lauren, is there any questions that you have or that others have that are like most pressing so I could get to them right away before I dive into this?
I feel like you kind of not glossed over, but covered some of that already, because people were asking, like, if that means defamation and all that is fully off the table. I think there was some misunderstandings there.
Yeah. Well, somebody had re-storied me on Instagram. Somebody had DM'd me a question. Right. And the way it was framed to me was with respect to the New York Times, and they like sent me like a paragraph of it, and they asked me what it means. It's like, well, it looks like it was denied in part and granted in part, and I didn't. But they put that out there as if I was stating that Baldoni wasn't harmed by this ruling. No, he was. Like
Yeah.
most of his countersuit was thrown out, and with prejudice. And so and that was before I even knew or even saw that your live was going on, and before I read this in 132-page ruling. And so, yeah, he's been harmed, but he is not dead. And the way that he's been harmed is he just cannot recover damages under those causes of action, but he can still plead the facts. He can still argue the points that are related to those causes of action, but he could have done that regardless of whether or not he brought a countersuit or not. So he can still defend. Sure. Everything is still on the table. That's really important. Everything is still on the table. All of Anita's theory on our website, and all the stuff that we've been carrying on about, all of those things are still arguable to a jury. There are legal reasons. I mean,
why defamation is a hard one to win, right?
It is a motherfucker.
That's what I thought. So, I mean, people are, obviously upset. And then, a lot of people speculate about the judge and the judge being biased and stuff like that.
Yeah.
I'm not arriving at that conclusion. That's, I don't fault people for having different opinions, especially because there's a lot of distrust in the system, I feel like. And so obviously I'm not trying to, like bag on anybody who does have that opinion. That's not really where I'm at. I feel like defamation claims in general, they're just really hard to
well,
win.
I think that it's really important. I think that this ruling should be a reset for everybody, because I think that there's a lot of people covering this case, and we're really, because we're human, we're so influenced by the PR narrative and everything that's out there. And there's been, I mean, even Ask Two Lawyers, they present themselves as like these objective litigators that are trying to be fair to both sides. There was like it wasn't an emotional plea, but there was a plea to like lower the temperature against Lively's side and Ezra and all these things, and they were defending them. I don't know if they were defending them as much as they were just saying, hey, why don't we just like calm down with like their snakes and all that kind of stuff. It's hard to do that. Look, part of that is if you want to start a YouTube channel, start rattling off about legal cases, these are not your colleagues, and they're certainly not your clients. Right, and they're going to have opinions, and strong ones, and they're not going to be shy to express them. And so you can't keep lecturing people about the emotional things that they feel when they learn about certain facts. And, granted, there's like hundreds of content creators that go on and they make content, and we get pulled into this stuff. I even think that I would even venture to guess that Ask Two Lawyers themselves have probably been persuaded somewhat by the PR backlash. I know that Stewart has been actively trying to push against that, but it's human instinct to like say, oh yeah, all this other stuff. The judge presumably is not up 12 hours a day watching YouTube on this case. Sure. Because he's a federal judge. He's got other cases. So all that he's being fed is the pleadings and what's been filed. And whatever conversations are going on behind the scenes, whatever's not on the docket, I don't know, and the letters. And so there is, look, we've stated, like in all of the coverage that I've had on this case, lost in what has largely been, I feel like my coverage has been largely pro Baldoni just because of my own personal opinion. I thought that he had a stronger case for his claims than Lively had for her SH claims.
I'm not really sure whose side I'm on, so.
Bullshit.
I was waiting for that. So just since we brought this up, and I see a lot of comments whenever we bring this up, inevitably, because people have a lot of strong opinions, and myself included, but I like the Ask Two Lawyers. I like Stewart as well. I know what you're saying. Obviously, I think I texted you about that because I was able to catch some of it the other day, and I was like, oh, I think they were mentioning, something you had said.
Yeah.
But I just want to say I do like those guys. I know, like, I don't necessarily agree with what they said in that. I don't think Blake Lively's a good person at all. I would actually go pretty far in the opposite direction on that one. But I just want to say if you're like a decent person and you don't have like bad intentions, I'm not gonna flame war with you over like difference of opinion. Even if
Yeah.
you are saying like, I don't think that we should be bagging on Blake so much. I disagree with that, but I'm not gonna try to hurt you. I'm not gonna go say like terrible things about you. And frankly, like a lot of times people take it too far in the comments, making like even like inappropriate kind of sexual comments about Stewart and Ezra Hudson, and I don't like that.
Yeah.
So I understand differences of opinion here, guys, but at the end of the day, I think that at their core, those are good guys. I'm not
No,
here to
I'm gonna
bag on them at
defend
all.
Stewart.
So I just
I'm gonna defend. Look,
yeah
I'm gonna do it. I know Lady made a reference to a comment that he made. I said that Ezra was like a snake in the grass or something like that. And he referenced that. I don't give
yeah
a shit about. Look, I stand by my comment. I'll say she could be a good litigator, and I can still call her whatever I want. How about that?
yeah
I didn't make any comments that were necessarily untrue according to what I've seen. And I could have opinions like that, and it's based on what I'm seeing in the moment. I don't mind him doing that, and I don't mind him having his own opinions about what he thinks of her. But I think that he's caught in like this situation where everybody has really strong opinions, and lawyers are not normally YouTubers. It's really
right
hard to get used to this um, avenue of communication because people are so you say the wrong thing or you think that you're trained. And Stewart, from what I understand about him, he's been an attorney for over 20 years,
hmm
and he's been taught to think a certain way, to give fair play to both sides, and to be objective,
sure
and to look, hey, I agree with this, but hey, they sure as hell make a lot of good points. And he's used to bringing that up in the contents of like working with other lawyers, and people just
right
kind of go along with that. But here he's probably getting thousands of people that want his head on a stick just because he's making some objective observations, which I don't agree with that, man.
yeah
Um, but just like he had some, he felt a certain way about my characterization of Ezra, I don't give a shit about that.
hmm
Um, Everything that
yeah
I've said about
yeah
this case has been trying to be objective. I'll never stand by the evidence laundering Van Sham lawsuit. I thought that was a shitty thing to do. And my understanding of that is Stewart and Keith both had said things to that effect, just not as strong as I did. And that's fine. But
hmm
the level of hate that I've seen them get just because they want to look at this case objectively is not fair to them. And
yeah
so
it's
I'll
also a
defend them on
little
those grounds.
it's a little worrisome as well. Just not just with those guys, but there's been other maybe even larger creators, I would say, in the last couple weeks or so that are just like going at each other's throats. And I'm kind of like, what is going to happen the first time? Like even people who are like, I get along with these people really well. I actually really like to work with them. Some of them I've like gone on their shows, they've gone on mine. But what is going to happen the first time we have a difference in opinion? Are you going to go to like Instagram or Twitter and like tell everyone what a terrible piece of shit I am?
Well,
Because that's kind of what it's looking like, and I don't really like that. I don't like the way this is going back and forth. It's bothering me a lot, so
yeah. I mean, no, I see a lot of that. But, a lot of that is kind of just par for the course. If you're going to get up on YouTube and talk, I mean, granted, I haven't really been affected by it all that much, but part of that is because I just don't give a shit about that kind of stuff. You can call me whatever you want online. I haven't
I
seen
usually
it,
do, man.
and you always do. Look, I'm not going to judge people for their opinions. You can support Blake Lively, and we could still be friends. I could have my opinions about her, and whether or not she's a good or a bad person, I don't effing know, man. I have no evidence to suggest she's a good person. I've seen some things that she's done in this case that lead me to believe she may be a bad person. I'm
Mhm.
certainly not the final arbiter of bad or good.
Yeah.
But with respect to this lawsuit, we need to bring it back and just say that, look, this is the way the judge sees the case, and he only sees it under this legal context without
Mhm.
all of the other vitriol that's being spewed back and forth between content creators or YouTube commenters or whatever.
Yeah.
Hey, this Ricardo congratulates Lauren Knighty for hitting 20K. I didn't even know that you did that. When did you
Oh,
do
thanks, man.
that?
It's probably a couple hours ago.
Oh, well, should we
I'm just
celebrate?
having a hard time being like I'm not having a hard time being too happy about that right now, so we'll put that off.
Oh, all right. Well, later,
Yeah.
later, much later at night.
It's just not a good this was not a good morning for news, obviously, so
Yeah.
I'm
But
not
again,
not too psyched.
you got Lauren and everybody else, you got to knock it off with that shit. Because look, you got
What?
to, it is a flesh wound. It is not fatal. Like the battle is still ongoing. There's still, if you're supporting
Yeah.
Baldoni's side and you're depressed over this ruling, I understand.
But depressed is a huge word, Omar. I'm
Okay.
still here. What are we talking about? No, I would say disappointed for sure. Disappointed to the
All right.
extent I would not wanna have a freaking party right now about my YouTube
Well, we'll do
channel, you
it
know what I
tomorrow.
mean? But,
Yeah.
like, I'm not gonna die, you know what I mean? It's
Oh, I know
fine.
that. Yeah.
Yeah, like I said earlier, I think some people are gonna say I'm crazy, but I really do have faith that
But
this
hey,
is gonna
check
go
this
his
out.
way
There's
in the
there are
ways that are
some
most important
openings.
to him.
There are some openings that Baldoni has to reassert certain claims and frame it in a different way. And
Yeah, yeah.
I think that he's going to do that, and he's going to have to use
Yeah,
those two causes of action to do it. But I think that this is not as bad as everybody feels right now, is what I'll say. I think that
right.
instinctively and intellectually, everybody also knows that. But losing always feels shitty. You know, you lost a big game, whatever.
Yeah.
The
Well, I mean,
season ain't
especially
over.
with people in our comments and stuff like that, just people we've been connecting with generally, and I'm getting a lot of messages today, which are that I think that's probably the hardest part is like seeing how a lot of other people are reacting to it too, because I feel that
Yeah.
because like this lawsuit in general is attached to so many emotional things to so many people that it's hard, I feel like, for people not to be upset. And then
Yeah.
it does I've never been in this position before where I feel like I'm getting a lot of like I've been able to connect with a lot of people, but I'm getting a lot of people reaching out to me with a lot of like really upset kind of emotions. And I'm like, yeah, I'm like, I really wish I could do something about this, but I cannot. So it's hard
Well,
to
could I give
kind of manage that.
I'm going to give my big brother pep
Yeah,
talk
please
right now.
go ahead.
Just like I wanted to give Stewart a pep talk the other day on his Friday show.
Yeah,
I kind of wanted to tell him, hey, Stewart, you got to calm your tits, bud. Like people are going to have opinions like that. It's okay. Like he was trying to like preach at everybody. We got to be fair to both sides. I don't understand why you guys are. You don't have to understand. You can't understand it. You can't understand the waves of YouTube commenters that are going to be upset about things. And trying to do that, you're just going to further depress yourself.
yeah,
And it's going to invade on what you're trying to do, which is be fair and objective and give top-notch legal analysis, right? And to the same effect, it's okay to feel what you want to feel. It is. And but what you have to do is you have to be able to move on from this and recognize it for what it is. And so just point blank what this is, fraud and defamation are out forever.
right.
That's it. All
Yeah,
the other stuff is in.
yeah.
He
I
has the
mean,
ability to bring in new facts and evidence that he's accumulated through discovery. We still don't know what's going to happen with the Van Sham stuff. That might
right.
still be coming.
I mean,
Um,
that's barely been touched on at
yeah,
all
but I
anywhere.
think the reason why that hasn't been touched on is because I don't think that Friedman is going to just bring a half-assed motion. If he has something
Right.
like that, he's going to have something concrete. And I think that he's kind of waiting for that to happen. Whether or not it ever comes to fruition, who knows? But there's other aspects of this case that need to be argued. And matter of fact, 100% of the timeline of events is still at issue. So that's it. The only thing that's happened is Baldoni's ability to recover under those causes of action are dead.
Mhm.
Whether or not that implicates 47.1 is an issue reserved for another day. And for that, we will see.
Yeah.
But because 47.1 is still at play, all of the other ways that he was attacking Blake Lively's SH complaints are more at issue than ever.
Right.
Because if it comes to pass that she brought a frivolous claim of SH, then 47.1 is not invocated and treble
Mhm.
damages shall not hold. And
Right.
what I'm unclear about is whether or not the judge has to make those determinations before trial or if it's a triable issue.
Mm.
It may be the case that the judge has to rule on those, maybe during a motion. So we'll see. But all of the ways that he was arguing in the context of fraud and defamation are still wildly relevant and will
Yeah.
be argued forcefully by Baldoni's side to implicate Blake Lively in that she basically brought a frivolous SH claim. He just can't say that she did it fraudulently or for defamatory purposes. Or maybe he
Yeah,
can. He
I
just
mean,
can't get it
not
worded.
in court. I mean, but this, like, really changed the way that the public was kind of looking at him and what she did. Just I know the claims were dismissed, but it doesn't mean that they didn't get a whole bunch of stuff out there that helped his cause as far as how people view him and his potential future working in the industry, so
Yeah. Let me answer some of these. VPan says, can he appeal the dismissal? Yeah, he's got 30 days from basically today to do that. He could do a motion for reconsideration. He can appeal it. I don't think they're going to appeal based on the rulings. It would be... What happened?
Hi, Stuart.
Oh, what's up, Stuart? Yeah, I believe that the standard would be on appeal an abuse of discretion or a mistake of law. I don't think that either one of those things happened. Sunflower Gardens with 5 says, I feel like this is premature dismissal because there was no discovery, if I'm not mistaken. What happens if Blake drops her lawsuit? Well, if she drops her lawsuit, then I guess it's over, right? But we still have 2 surviving causes of action on from Baldoni's side that needs to be litigated. I don't foresee Lively dropping her lawsuits. I don't see why she would do that now, unless she thinks that she's going to be under fire for like a frivolous SH claim, which would not protect her under 47.1 and lots of other things. But yeah, if she dismisses it, then she dismisses it. But discovery, if she dismisses it and Baldoni still continues, discovery is still ongoing. I think that's the heart of your question. They have to both dismiss for discovery to no longer be a thing. If Baldoni's entire lawsuit got thrown out, he could still conduct all the discovery he wants because he's still being sued by Blake Lively. And so that's kind of how that works. Alexandria Ison with a 5 says, lots of this question, can Justin appeal defamation claims and should he? I don't think, based on the ruling, and look, I'd have to sit with this for another couple of days, but based on what I read, it seems pretty clear cut that the judge interpretation of the law is based on a string of precedent, cases full of precedent that they didn't bring a claim that is actionable. And so the chances of winning on appeal appear at first glance to be pretty slim. I wouldn't, unless they could do the research and find an angle where they clearly got the law wrong. I don't see it right now. Maybe in coming days, maybe other content creators out there will find something. I just haven't seen it yet.
Sure. I don't know that David really necessarily want to do that either. I mean, this seems like a lot to be going through right now. I don't know if he would really even want to do that.
Well, I think you got to give yourself a couple of days to sit with this and figure out what you want to do. You got 30 days for a reason. They give you 30 days, not 3. So use them, and regather yourself and take a deep breath and figure out how's best to proceed. And if you're going to appeal, then you better have a pretty good reason for doing it. And so I don't want to make any calls on that yet. Just add air says, disappointed is the word of 2025. Hugs to everyone. I hear you. I know exactly what you mean. Going back to that. Well, I should probably get into some of this stuff. Some of the legal things, because I think a lot of people have legal questions. I mean, you could summarize the law pretty easily. They brought a defamation claim. They didn't make a prima facie case. They didn't plead an actionable case. There was issues with the statements. There was issues with them proving malice. There's issues with them connecting the dots. They were just unable factually to bring a claim. And that's kind of what 12b6 is for. And so let's just get into some of this stuff. I'm going to, if there's a comment out there, Lauren, that you think I should read, let me know. Cause I'm like, I'm
reading. You're asked at reading the comments. Yeah. Okay.
Yes. Okay. All right. So he talks about the parties. I thought this was important. At this time, the court will not grant the motions to strike Exhibit A from the dockets. Federal Rule of Procedure 12F authorizes court to strike any redundant, immaterial, impertinent, or scandalous matter from a pleading. Federal Rules 12F, Exhibit A, is largely redundant of the amended complaint, and given that it must be disregarded as immaterial to the court's decision on the motion to dismiss, meaning it doesn't matter. But the fact that material is irrelevant or must be disregarded generally does not justify striking it from the docket, unless permitting the allegations to stand would result in prejudice to the movement or the moving party. They talk about addressing this at the conference on February 3rd. Counsel for Lively and Reynolds expressed some concern about the use of the attachment on a website created by defense counsel and stated that they would have moved promptly to strike the exhibits. But the earliest motion to strike was made by Sloan was on February 20th. And Lively did not move until March 18th and 20th, More importantly, none of the motions mentioned anything about improper or prejudicial use of Exhibit A. Motions to strike are generally disfavored and should be granted only when there was a strong reason for doing so. And if you're looking for fair and balanced, if they really thought it was all that prejudicial, they should have moved to strike right away, as they said they were going to do on February 3rd. This judge observes, look, you said you were going to move to do this right away on February 3rd. You took over a month. So what's the prejudice? You must not think it's all that prejudicial. By contrast, when they moved to strike Friedman's letter and his declaration regarding the extortion issue for the Van Sham thing or whatever it was, he moved within an hour to strike that because they did. And then he found it to be prejudicial. So if you're looking for fair and balance, he's applying his rules pretty evenly, at least based off of that.
Okay.
He goes on to some other recitals. I'm not going to get too much into the background because if you don't know the background by now, you shouldn't be starting with this video.
No, this is not a good place to start, man.
Yeah. So I'm going to skip over some of this stuff, and I highlighted some things, but those are just key things that I was looking for. I want to get her 17 thing, or 17 point letter. Then we get to scrolling all the way down. Where are we at? Oh, he's still on to the background. Yeah, that's how big this case, how convoluted the facts in this case were. We're on page 23 and still going through background stuff before.
Well, none of this none of this has anything to do with Stephanie Jones. That's going to be a separate issue. So
yeah,
people were asking about that. So
no, it is. I highlighted this because some of this was related directly to what he said later. I don't think anything's happened in the New York Times. I think the complaints against them are getting dismissed. I mean, they have kind of already, but
yeah, it's unfortunate. I mean, like I've said to people before, I think that what they did was shitty practice from a human standpoint, but I don't know that legally they are really going to get any trouble.
I think I told you that directly. It's like, what exactly did they do wrong? So, okay, so they didn't, so they might have shared 1,000 text messages. Some of them might have been defamatory. If the thing that they reported on was only the CRD stuff, then what did they do wrong? And they're like, yeah, but it's still shitty. He's like, okay, but
It is though. It is still shitty.
All right. And maybe it was. I mean, I don't know. Either way. So legal standard to survive 12b6. The ultimate question is whether a claim has facial plausibility, meaning it's not ridiculous. Like there's some plausible set of facts that lead to a cause of action. The plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Determining whether a complaint states a plausible claim for relief will be a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. And now they get into this discussion. I thought this was really important. So first, Wayfarer parties claim that Lively, assisted by Reynolds and Sloan, stole the film from Baldoni and Wayfarer, threatening to refuse to promote the film and attack Baldoni and Wayfarer in the press if the Wayfarer parties did not agree to grant her, rather than Wayfarer, control over and credit for the film. So the way that the judge is thinking about this, just spoiler alert, is this is straight up just bargaining. And remember way early on at the beginning of the stream, Lauren, when I told you that some of the stuff that I was talking about way back in like December or January was going to come back to bite Justin in the ass, because it was like 100 different times she like makes her own demands and changes things and reschedules things and readjusts the budgets. And they keep on praising her about what a valuable asset she is and how she's so valuable. She's such a great actress and she's so creative. And they keep on acquiescing to her demands throughout the production cycle. And they get a movie made. I told you early on that looks a lot like modifying the contract, or like the judge said, hard bargaining. I called that out back in January. And so this is where it's biting him in the ass right now. It's like, how was that fraud or extortion if you kept on agreeing to her demands? You should have brought a complaint way back when. I remember I had Bruce on. I said, why didn't they just like file a lawsuit like way back then, that she's being ridiculous and get her off the film and bring in somebody else? But they didn't do that. They kept her on, and they kept on giving in, and they kept on in writing, talking about how talented she was. And then they try to sue her for fraud and extortion. That doesn't make any sense to this judge.
Yeah. I
And
know.
if you're looking for why that doesn't make sense, way back when, it's because if you're still agreeing to modify the contract, then technically what you're basically doing is bargaining, going
Mm.
back and forth. And it's the back and forth and the acquiescence to it that is problematic for Justin. And so the way that the judge frames this is the Wayfair parties claim that Lively assisted Reynolds and Sloan to stole their motive was to steal the film and to remove credits and all that other kind of stuff. The way that the Baldoni supporters, namely like Anita, have been framing it is that, well, that was the motive all along. And she was planning this all along. And then she used SH when she knew it wasn't going to go her way or the threat of it to gain her motives. So we established it like it was this motive that they had.
Yeah.
Which might have been true. But if it's a motive, if you're bargaining for the thing that you have a motive for, how is that fraud or extortion? That's what the judge is saying in writing in this ruling. Does that make sense? I know I didn't do the best job of outlining that.
No, I think you did. It's just like I have a hard time reconciling, like what you're saying makes sense in this context, but I'm having a really hard time reconciling just outside of that, just in my mind, like thinking about somebody using the threat of like coming out and saying somebody's going to you sexually harass me or whatever as a bargaining chip. And I know that's technically not what that document said, but we all know what that was. So,
Yeah.
you know.
No, well, I agree with you. And that's why I'm saying that you can still have that opinion right now. You can still say that she basically used SH as a bargaining chip. Now, if you do that, and you could prove that on your defense, then I don't believe she's protected under 47.1. And guess what? I think that I'm willing to bet that 47.1 is now in play as treble damages.
Mm-hmm. Well,
and they're going to have to go after that angle harder than ever because otherwise treble damages will apply. I think that the way that you get past the SH claim is by stating that it was a bargaining chip. The judge is already thinking like that. The judge is already, he's already considering that you have two parties that are bargaining. But if she's using SH to kind of force Baldoni's hand, which I don't think he's thinking that way at all, otherwise he would have let some of the other claims stand. That's how you get rid of 47.1. But you're going to have to prove that. And the way that the judge is framing this right now, he doesn't see that at all.
Gotcha.
I'll tell you what, Anita, in her theory, she's bent over backwards to try to make this fit. But the pleadings and the way that they're stated right now does not paint a clear picture. It's the reason why, like when she first came on the show to talk about that claim, I didn't see it at first because what was being pled and then what she was saying, she was having to stretch all of these elements together. The judge just flat out says, I'm not doing all of that.
Yeah.
He bold-faced said that right now in this ruling.
Yeah.
So that's where we're at with that. Anyway, he frames this. He says the Wayfair parties seek damages for this conduct based on a legal theory that Lively, Reynolds, and Sloan committed civil extortion. Second, the Wayfair parties claim that Lively, Sloan, Reynolds at the time spread a false narrative that Baldoni committed sexual misconduct towards Lively, and the Wayfair parties then engaged in a smear campaign to ruin her reputation. The Wayfair parties cannot recover for Lively's alleged actions to steal creative control of the film from Baldoni and the Wayfair parties. Regardless of the propriety of these actions, they do not constitute civil extortion under California law. And then they go on to explain why that is. California courts have recognized that a claim for civil extortion in situations where a plaintiff gives a defendant money or property under threat and seeks to have it returned. In other words, it's a tangible thing. However, the Wayfair parties have not adequately alleged that Lively's threats were wrongful extortion rather than legally permissible hard bargaining or renegotiation of working conditions. Additionally, the Wayfair parties have not shown that some of Lively's allegedly extortionate acts damaged them. The Wayfair parties also cannot recover on their defamation claims. The Wayfair parties have not alleged that Lively is responsible for any statements other than the statements in her CRD, which are privileged. The Wayfair parties have alleged that Reynolds and Sloan made additional statements accusing Baldoni of sexual misconduct, and that the Times made additional statements accusing the Wayfarer parties of engaging in a smear campaign. But the Wayfarer parties have not alleged that Reynolds, Sloan, or the Times would have seriously doubted these statements were true based on the information available to them. And that's important because that's basically the standard of malice.
Yep.
If you can't show that, then you have no avenue to proving malice, as is required for them to be liable for defamation under applicable law. Interestingly, I said that funny. My voice cracked.
You're good, man.
Interestingly, the Wayfarer parties plead their claims under California law, which is something that I forgot. This whole time I've been just thinking about this case as if Ezra and the Lively parties were the ones that utilized California because of 47.1. I completely forgot that the Wayfarer parties are the ones that wanted this to be litigated under California law. Boy, is that backfiring. The Wayfarer parties plead their claims under California law. Lively agrees with the Wayfarer parties that California law applies to the claims asserted against her. However, Sloan, Reynolds, and the Times argue that the New York law applies to their to claims against them. Dispute is important because New York and California law differ in a number of different ways. I'm not going to get into too much of this stuff because it gets really convoluted about some of the differences. But it basically concludes with this. Because it is unclear from the pleadings where the facts underlying the claims against Sloan and Reynolds occurred, the court cannot dismiss the claims based on a holding that they must be brought under New York law. If the allegations state a claim under California law, the claim must be allowed to continue until such time as the facts developed show California law does not apply. Therefore, the court will analyze the claims against Sloan and Reynolds under California law for purposes of this motion only.
Hold on. I'm going to show my screen real quick.
Okay.
This is fucking infuriating. Okay. All right. You have to let it on the. Pull it up.
All right.
Let me see if I can zoom into that. I don't know if it'll let me. Last week, I stood proudly alongside 19, I think it's something, defending women's rights, the organizations that did the Amici briefs, to speak up for their safety, defending the women's right to speak up for their safety. Like so many others, I felt the pain of a retaliatory lawsuit, including the manufactured shame that tries to break us. While the suit against me was defeated, so many don't have the resources to fight back. I'm more resolved than ever to continue to stand for every woman's right to have a voice in protecting themselves, including their safety, their integrity, their dignity, and their story. There are protections out there. Check out some of the incredible organizations below for resources and information. With love and gratitude for the many who stood by me. Many of you I know, many of you I don't, but I will never stop appreciating or advocating for you.
Who wrote that? Is that Lively? I can't tell. Oh, it is. It literally says it right there, doesn't it?
Yes, it does.
Oh, well, listen, much like, look, this is a lot like Laura Owens winning her OOP against Eckert way early on. And then, it's like, oh, this is bullshit. This is a travesty of law. But, lost in all of that was that they weren't litigating whether or not she was pregnant or not. So this motion was not about whether or not this was not about the validity of her SH claims. Let's not mistake that. This is about the validity or the plausibility of the defamation and fraud claims against Baldoni, or that Baldoni is bringing against her.
This statement is, I'm sorry, this is fucking diluted. I know you might not agree with that, but no, I'm done with that.
Well, I have thoughts about it. I understand your emotional reaction to it. Mm-hmm. If you believe that Lively is full of shit with these SH claims, of course, it's going to be infuriating. Yeah, and I think the majority of people are out there. But you also have to understand that she's probably sitting there like thinking that this is like a huge victory for her, as she well should. Her and her lawyers are sitting here, hey, here's a big win. Of course, they're having like a big party over there at that firm or over the phones or text messages and joys and hugs and tears. And she's going to feel empowered by this. This is one of many battles, and she won this one. So she's going to take a moment to gloat.
It has nothing to do with fucking women's rights organizations or even that man sexually harassing her. And I hate that she's conflating the two because people are going to buy it.
Well, to that degree, I have come out and stated my thoughts about her advocating for women's rights on the strength of those SH complaints. And I'm not going to repeat them here because I was pretty harsh against
Yeah.
her, but she's
Okay.
entitled to say whatever she says. I'm not going to, well, I'm not going to share my opinions of what I think.
Well, then
about
I'm
this.
entitled to call her a cunt, man. I'm sorry.
By all means.
That's a
By all
cunty
means.
thing to do. Like, I'm so fucking sick of this.
Yeah.
The ruling was
not
the
mad at
ruling.
you.
It is what it is. Like the ruling, I understand. This right here is the stuff that gets to me. So
No. Yeah, I know what you mean. I know what you mean. But I'm trying to stay unemotional as I'm going through this exercise of
yeah, I'm
reading.
failing on that a little bit at the moment. But
Oh.
you know, if you want to go back to the boring shit, that might help, please.
Well, I mean, I think I'm just gonna. You made me lose my place. Oh, here it is. All right, cool. All right, so the Wayfair Parts defamation, false lie claims based on allegations, Slow made false statements. We got through that, I think. It's unclear from the pleadings where the facts underlying the claims against Sloan and Rounds. The court cannot dismiss the claims based on a holding that they must be brought under New York law if the allegations state a claim under California law. Anyways, I'm not going to read this because this was kind of immaterial to the decision to dismiss some of these claims. Yeah, let's just move on from this because of time. He talks a little bit about impermissible pleading. This is where he makes the line, look, I'm not going to clean up your complaint for you. You guys can do it yourself. This issue is compounded by the fact that the complaint's lengths and tangents make it difficult to understand exactly how the facts alleged provide a basis for plaintiff claims. Dismissal under Rule 8 is usually reserved for those cases in which the complaint is so confused, ambiguous, vague, or otherwise unintelligible that its true substance, if any, is well disguised. The Wayfair Party's amended complaint is lengthy and repetitive, and it relies heavily on group pleading, but it's not so confusing or lacking in substance that dismissal is appropriate. Anyway, he didn't dismiss it on those terms. Lauren, to your point, this is, you know what? I'm going to share what I think because I know you want me to about Blake Lively. Do I think that she should be positioning herself as a champion for women's rights on the strength of what I believe, based on what I've seen, to be frivolous claims of sexual harassment? No. And I think it's disgusting that she's doing it on the strength of these claims when I have personally represented plenty of genuine victims of domestic violence and sexual assaults and sexual harassment who had like severe claims and cases and had no ability to fight against the people that they were fighting against. And they stood and they did their thing.
Bitch has no right to claim to be an advocate for those people, in
No.
my opinion. So that's what's
well, here's what's, I mean, I think that you add to that Justin Baldoni has spent the better part of the last decade advocating for women's rights in the way that he's done it. And all Lively and her husband has done is make fun of him for doing that, calling him like a male feminist. I don't know why that's a bad thing. Calling him they made like that video, like kind of like making a joke over his position and his stance.
You know, the Deadpool bit. Yeah. Yeah,
and trying to eradicate his image. And, you know, he's this and that. He's a sexual predator, even though he's done really good work. His entire motive behind the creation and the production of this film was to advocate women in their positions of domestic violence. And here comes Blake Lively inviting people into her trailer. You look at her cross-eyed, and now it becomes the basis to form her sexual harassment cause of action. That's disgusting. And it's going to rub a lot of people the wrong way. I'll make a separate video about that maybe later tonight. I have to stay focused because I have to be, you know, I got to be disciplined.
Yeah.
But I had to get that off my chest. Otherwise it was going to itch my brain.
I hear you.
Yeah. So the judge goes on to state where the amended complaint does lack clarity, the court will consider only the claims. Again, I'm going to skip over a lot of this because a lot of this was not the basis for why some of these causes of action were dismissed. Now, so civil extortion. The Wayfair parties alleged that Lively refused to return to production unless the Wayfair parties agreed to her return to production demands. That Lively threatened to abandon her contractual obligation to promote the film.
Why don't you fucking abandon your Instagram account? For fuck's sake, man.
You all right, Lauren?
No.
or approve marketing.
Yes, but no.
I understand. Or approve marketing materials unless the Wayfarer parties agree to co-fund a screening of her version of the film. Eventually release that version and grant her a producer credit and support in seeking the PGA designation. That Lively threatened to boycott the premiere unless Baldoni was excluded. That Lively and Reynolds threatened to attack Wayfarer in the press if it did not take the blame for problems during the filming. That Sloan carried out Lively and Reynolds' threats by spreading false allegations that the Wayfarer parties had engaged in a concealed sexual misconduct. That's what the judge is getting from their complaint. That's the gist. And then he says that the Wayfarer parties argue that they are not required to allege a transfer of money or property, and that the threats alleged in the amended complaint are sufficient. And to be fair, when I read that earlier, it was my opinion that they should be able to bring this claim of fraud or civil extortion if the thing that they are trying to steal is the movie, because it has inherent monetary value, even though it might not be this tangible thing just yet. I thought they were going to be able to survive a 12b6 on that basis, and so did Friedman. Anyway, Lively, Sloan, and Reynolds have the better argument here. They say that Lively, Sloan, and Reynolds argue that none of the alleged acts are wrongful and that they did not obtain money or property from the Wayfarer parties. My argument was, and Friedman's argument was, yeah, but the movie rights, the movie credits, and other tangible thing or untangible things. And then the judge says, well, Lively and Sloan, they have the better argument. And then he goes on to state this. The Wayfarer parties allege in several instances that they took actions desired by Lively because of her past threats or because of a general atmosphere of threats and fear. Specifically, Baldoni realized after the return to production demands that he needed to cede control of the script to Lively. And the studio agreed in light of Lively's threats to do an official audience test of Lively's version of the film. These allegations fail to connect particular threats by Lively with particular demands. And it is at best unclear whether the Wayfarer parties are alleging that Lively threatened to take a particular action unless the Wayfarer parties gave her control of the script or agreed to an audience test. Now, I read those facts, and I thought that that's exactly what it did. Like, what would be the logical conclusion reading those things? I just felt that plausibly it connected the dots just enough. The judge disagreed. They talk about some of the governing law. I'm going to skim through some of this. And they get into this discussion about what California permits and the differences between it and federal law. California permits plaintiffs to bring a claim labeled civil extortion. However, an action for extortion under California law is more appropriately considered a claim for monies obtained by duress. In other words, the California tort is based on the common law concept of duress rather than the statutory elements of criminal extortion. Although the concepts of duress and criminal extortion are similar, the lineage of the tort clarifies 2 points.
I'm gonna get I get some more water. I'll be right back.
Oh, okay. First, if a threat would not support a contract claim for duress, it is not sufficient to support a tort claim for civil extortion. Second, and of equal importance, in order to state a civil extortion claim, the plaintiff must allege that they suffered damages or lost something of value as a result of defendant's threats. The threat alone is sufficient. And again, I think what the Baldoni parties were going after was they lost something of value, meaning the PGA credits, meaning artistic rights to the movie, maybe the franchise in general. They're claiming they lost something of value. The few published California cases discussing the tort involve the return of money conveyed due to a wrongful threat, a situation in which the cases analogize to voiding a contract made under duress and receiving restitution. And then they go into some more discussion about the law. In Furman, the plaintiff brought a claim for extortion, alleging that the defendants baselessly accused her of illegally receiving satellite broadcasts and threatened to sue her unless she paid them $275 to settle the claim. The California Court of Appeal held that a claim for extortion was cognizable, rejecting the defendant's argument that extortion is only a crime and cannot form the basis of a civil action in torts. And at the same time, Furman did not discuss or even mention the criminal extortion statute. Rather, it described the relevant claim, however denominated, as essentially a cause of action for monies obtained by duress, which is a form of fraud. The court suggested that if the plaintiff had actually paid the money demanded by defendants, she could have recovered the money. However, if dismissed, it dismissed the claim because she had not paid the demand and therefore had no claim for relief. In other words, she had no longer any damages, therefore the claim could not prevail. And then they make a parallel to that case here. A civil extortion claim under California law will not lie in the absence of a threat that would be sufficient to support a claim of duress. Duress generally exists whenever one is induced by the unlawful act of another to make a contract or perform some other act under circumstances that deprive him of the exercise of free will. And what Baldoni was saying, the only reason why we were giving in to her claims was because we couldn't proceed. We had no other avenue during production or in post-production or during the advertising of the film to do anything different. And the judge is saying, you have not shown me how that's true. It seems to me like you had other options. And if you're failing on that element of the cause of action, then you really don't have a cause. If the judge sees it that way, I could understand his reason for the dismissal. They get into this discussion about criminal extortion. The law of criminal extortion may help elucidate the civil concept of duress. And indeed, some civil courts or California courts have drawn on it for this purpose. However, the list of wrongful acts that will support a claim for civil extortion is neither defined nor limited by those listed in the California Penal Code. Rather, courts rely on the broader body of jurisprudence, describing what types of threat are both wrongful and sufficiently coercive to cause a reasonably prudent person faced with no reasonable alternative to succumb to the perpetrator's pressure. Furman also makes clear that a civil extortion claim requires actual damages. Furman stated that the fatal flaw in plaintiff's action is that she apparently never paid the money defendants demanded in the letters, and dismissed the case on this ground. Accordingly, a civil plaintiff cannot recover simply for being threatened. And so, tangible threats, the difference between actual debts, the difference between actual damages and prospective damages is this. You know what your actual damages are. In other words, Lauren, you just went on a trip to Australia. Let's just say that you went all the way to Australia and the hotel double booked and you were asked out of a room and they had to go book at some lesser place or had to I don't know, you weren't able to be accommodated and you paid them. You actually paid them money, but they had this non-refundable, no refund policy. And you paid them $10,000 because they were staying at the Four Seasons for, I don't know, however long. And you have actual damages in the amount of $10,000. That's something that you need to, that's not something that you need to find in discovery. Your actual damages are $10,000.
Who did they give my room to? I mean, who did they give my room to? Is she hot? We could share the room. I mean, it's not a big deal.
They gave it to, I don't know, another gay guy. How about that?
Yeah, that's fine. I like gay guys.
Yeah, but not to the, all right, well, go ask him. Maybe he'll let you in. Maybe you guys could stay and room up together and grill and make grilled cheese. Maybe some.
I mean, he can have the little. There's like a futon over here. He can have that.
All right. Watch tonight. Somebody's gonna knock on your.
Yeah.
Hey, I was supposed to be booked in this room. You mind if I shack up with you? I feel that coming in your near future. Anyway.
Yeah, me too.
They denied his claim.
God damn it.
They denied his civil extortion claim because he didn't have any actual damages. And the judge is interpreting that. You can't just state some prospective thing. There's prospective damages and there's actual damages. Actual damages, you don't need discovery for. You didn't plead any actual damages. Therefore, the claim fails on its face. And there's no amount of amended pleading that is going to somehow rectify that issue based on what you've already put.
Stephanie says you can eat steak with your hands together. It was one time. Okay? One time I did that.
Sometimes I remember that stream.
Yeah, that was Clayton's response to the appeal, wasn't it?
I'm only on page 56, so I'm going to skim through some of this.
Yeah, I don't know if Stuart asked if we wanted to come on at 2:30 to theirs. I told him yes, but
yes.
Okay, good.
Let's do that. When's it, like in an hour? Does it mean 2:30 our blah? I can't even talk. 2:30 our time. Yeah, I'm down for that.
Cool.
All right. I'm going to try to get through this by then. How about that? And then we'll have a much more intelligent conversation with Ask Two Lawyers because I'm not getting derailed by.
I'll use ladylike language and everything. It'll be good.
Oh, if you don't use the word cunt at least once in their stream, Lauren.
I am not going to say cunt on the Ask Two Lawyers channel. They are respectable people, Omar. I'll say it on your channel.
At least I know what you think about me. So.
I love you.
I love you too. Anyway, you're coming back over, right? This weekend or something?
It's a weekend. No, I'll be a couple days from now.
Oh.
I leave on Friday, but I'll be there Tuesday. Yeah.
All right.
Yeah.
We'll have to plan something. Okay, the Wayfarer parties argue to the contrary that a plaintiff can recover for civil extortion even if no money or property was obtained. The argument relies on a district court decision. And then they state that this case is just kind of bullshit. Monix, which inferred a private right of action from the extortion provision of the California Penal Code. No published California case has adopted the reasoning in Monix, and the decision has been largely disapproved by the federal courts for that reason. At least one published California decision has expressly stated that Monix contradicts Feuerman and does not reflect California law. To the extent the court in Monix concluded a claim for duress or extortion had been stated in the absence of an allegation of accession to the demand, its decision was contrary to California law. In other words, the only case that might have allowed Baldoni to proceed has been deemed non-persuasive by this federal court. Accordingly, to plead a tort claim for civil extortion under California law, it is neither necessary nor sufficient for a plaintiff to plead the elements of a criminal extortion. Instead, the plaintiff must plead a wrongful threat constituting duress to which the plaintiff acquiesced, causing damages. Justin didn't plead that. That's why it's getting dismissed. Here's the application to our case. The last set of allegations is not actionable because Wayfarer did not acquiesce in the threat and did not accept blame for this. Actually, this whole paragraph is important. The Wayfarer party's civil extortion claim is based on allegations that Lively refused to return to production unless the Wayfarer parties agreed to her return to production demands, that Lively threatened to abandon her contractual obligation to promote the film or approve marketing materials unless the Wayfarer parties agreed to co-fund a screening of her version of the film, eventually release that version, and grant her a producer credit and support in seeking the PGA designation, that Lively threatened to boycott the premiere unless Baldoni was excluded, and that Lively and Reynolds threatened to attack Wayfarer and the press if it did not take the blame for problems during the filming. The last set of allegations is not actionable because Wayfarer did not acquiesce in that threat and did not accept blame for problems during filming. Interestingly, what if they did? Is he saying then that the claim is actionable? Wayfarer did not lose anything that Lively and Reynolds did not gain anything from the threat. The remaining allegations must be dismissed because the allegations regarding Lively's wrongful threats are conclusory and fail to support that the threats were wrongful. In addition, the Wayfarer parties have failed to plead that several key instances of alleged extortion caused actual monetary loss. And so there's that. I highlighted this why. The Wayfarer parties alleged that in response to threats that Lively would stop acting in the film or breach her contractual obligations to promote it, they were forced to agree to return to the production demands, give Lively greater control over the script, give her a producer credit support in seeking PJ Mark. However, Wayfair does not plead sufficient facts to support an inference that these threats were legally wrongful. How is this disallowed? How is this not just hard bargaining? Because it seems like that's been the nature of their relationship for like the last year.
Yeah, I get what you're saying. It just feels gross.
Yeah, it's gonna feel gross. That's what I'm saying. Do not we should not overstate the effects of this ruling. It is what it is, man. No defamation, no fraud. Fine. You can still argue whatever you want to argue to defend Justin. It's all in play. Nothing's been stricken. All of Exhibit A is in. I mean, it's not in like a trial, but it's not been stricken. You know what I mean?
Yeah, I got you.
All right. The Wayfair party's claims do not turn on what Lively threatened to do, but what she threatened not to do. The Wayfair parties allege that Lively threatened to refuse to promote the film or approve any related marketing materials, and threatened to abandon her contractual obligations to promote the film or approve marketing materials. However, Wayfair parties not allege facts showing that Lively had an obligation to promote the film or to approve marketing materials. In other words, they did not define the contract. So that's coming back to bite them in the ass. But they're going to be allowed to reframe that in their amended complaint. So let's not overreact to that. In their amended complaint, they are going to have to say specifically what the contract was, which is going to be fascinating because there was an initial contract and then there was like a million different modifications of that contract. That's going to be fascinating to me. For the nerd in me, that will be fascinating. The Wayfarer parties allege that the Lively... Oh, I read that, didn't I? Anyway, let's get on with this. It thus is not uncommon in commercial relationships that one or the other party will demand that a condition to their agreement change before performance is rendered, or refusal to perform unless the counterparty agrees to additional consideration, or a new term may, depending on the circumstances, give rise to a claim for breach of contract. We don't know what the freaking contract was, though. So they're going to be forced to reframe that. In the absence of a continuing condition of duress, the party can agree to a modification. This is what I was saying back in January. And here it is. In the absence of a continuing condition of duress, a party can agree to a modification by either express consent or conduct inconsistent with anything other than approval. In other words, you know what, Blake, you're such a genius. We'll just do it your way. Whatever you said, we'll just do it like that. $5,000 budget for wardrobe? Let's do it. You want to film at 10 p.m. as opposed to 9 a.m.? Go for it. You have these 17 conditions? Okay. And every single time she would have a demand, they would acquiesce. In those circumstances, the new agreement will define the relationship between the parties. All of these conduct inconsistent with anything other than approval, every time that happened, it changed fundamentally the contract. And they're going to have to go through the exercise of defining for the judge specifically what that was. And that kind of sucks because there was no written contract signed, is my understanding. And the agreements and understandings of the parties kept changing up until the date that this lawsuit was filed, honestly.
Right.
Every time you say right like that, I feel like you were like zoned out.
No, I don't want you to think that I zoned out, so I say a word every now and then.
I'm just you know what I'm just saying is like I don't have Lauren on flat anymore because she gets like complete and total ADD for like in 10 minutes and she'll malfunction and then she'll like call me a cunt and then she'll peace out.
It does not take 10 minutes for that to happen, man.
It's like, oh, she does not have the attention span for a 2-hour show.
Flat can't handle me, man.
No, it can't. It can't. We've tried.
Yeah, it's pretty bad.
So they have this whole discussion, and we're going to see where they're going on this. The facts alleged do not support an economic duress claim. The way parties first alleged that Lively threatened and all this stuff. The only apparent cost to the Wayfarer parties was hiring an additional producer. Other than that, what was the economic duress? Allegations do not support that Lively was attempting to extort the Wayfarer parties into hiring a producer, as opposed to seeking to confirm previously understood terms and conditions, or at worst, seeking slightly more favorable terms of employment. In other words, the judge is just not seeing it the way that it's being framed for him. The amended complaint is not clear whether the Wayfair parties, as opposed to Sony, had the ultimate right to choose the cut of the film that would be distributed or the marketing plan that would be used to promote the film. There are indications that the amended complaint that such rights resided with Sony. Anyway, they were not without reasonable alternatives. The Wayfair parties state that Baldoni was forced to choose between killing the film and his own career by insisting on his own creative rights and visions. At the point these threats were made, filming was complete. If the Wayfair parties had the right to put out a film with Baldoni's edits in the first place, they were not without the ability to do so. In other words, they had options. And so how could you claim fraud, extortion, duress when you had alternatives? And what would have been the big, how would you have been damaged by going with any of these other alternatives? That's what the judge is asking. And he goes on to say that on, and like, oh, there's this part. The injury of the Wayfair parties' focus on regarding the PGA mark is essentially a moral injury, that they believed that Lively did not perform the duties of a producer and therefore did not merit the PGA mark, but were forced to write a letter omitting the truth. Moral injury. The only instance in which Lively and Reynolds allegedly threatened to spread defamatory statements was in demanding that the Wayfair parties make a harmful public statement. And as stated above, the Wayfair parties never provided such a statement, so no conspiracy related to the statement is actionable. In other words, what did they want you to say, or what was the statement, or whatever? Which, I got to be honest, it's a little confusing to me, because if that was the issue, don't we actually have the email in question where she's directing him exactly what to say? Lauren?
Sorry, what?
Oh.
I did space out that time. I'm sorry.
No, I was just stating that this part of it is a little confusing for me, because he says the only instance in which Lively and Reynolds allegedly threatened to spread defamatory statements was in demanding that the Wayfair parties make a harmful public statement. The Wayfair parties never provided such a statement, so no conspiracy related to the statement is actionable. But I thought that they not only did they provide the statement, but they provided the email where it came from.
Right.
I'm a little confused by this.
What's confusing? I don't get what's confusing.
Well, if they're stating this is what, okay. The judge says, finally, there are no allegations supporting Reynolds or Sloan's liability. The Wayfair parties argue that Sloan and Reynolds are liable in conspiracy because by actually spreading defamatory statements, Sloan and Reynolds played the role of the heavy, carrying out Lively's extortionate threats. But the only instance where that occurred, in which Lively and Reynolds allegedly threatened to spread defamatory statements, was in demanding that the Wayfair parties make a harmful public statement. And as stated above, the Wayfair parties never provided such a statement. Oh, meaning they didn't make it.
Yeah. I was like,
Okay.
I'm confused as to why you were confused about that.
I thought he was talking about the pleadings. I'm sorry. Never mind.
No, they did show the actual. They showed the actual. Yes, I get what you mean.
Well, I just wasted like whole 5 minutes on that. So, defamation, legal standard. Defamation constitutes an injury to reputation. They go about the legal standards of this stuff, and I'm going to just really sprint through because I want to wrap this up pretty soon. They're having a legal discussion of what defamation is, but this was kind of the heart of it. They get into some of the 2020 47.1 stuff. In 2023, the California legislature provided a privilege for a communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination. This legislation was a response to the Me Too movement and expanded on an existing privilege which protected complaints of sexual harassment to an employer or a court. And by the way, I'm not going to get this question. The judge wrote a footnote in here stating that, look, I know there's been a bunch of amicus briefs filed. I did not rely on any of those briefs in my making of this ruling.
I didn't see that.
Oh, it's in one of the footnotes.
Gotcha.
I may or may not have highlighted it. I don't remember. Um,
People are asking if I'm high. No, I'm not going to break the law overseas. So no, I'm not high.
no, you're just jet lagged and
Thanks
it's like
for
6
asking
a.m.
again.
where you're at.
No, I mean I've been awake now since 2 and it's almost 7. So
Hey, you and your sleep. Well, I mean, I guess Australia, no. Communication is defined as factual. Okay, the legislation also provides that a plaintiff brings an action for making a communication that is privileged under this section. The prevailing defendant shall be entitled to the reasonable attorney's fees and cost for successfully defending themselves in the litigation, plus treble damages for any harm caused to them by the defamation action. And whether or not that applies is going to depend on future filings. The Wayfarer parties have not adequately alleged a defamation claim as to any part of the purported conspiracy. The Wayfarer parties have not adequately alleged that any false statements were made to the Times other than the statements in Lively's CRD complaint, which were privileged under California law. There's also no allegation that the distribution of the CRD complaint was made by anyone other than Lively, or more particularly in the involvement or agreement of Sloan or Reynolds. In other words, whether or not 47.1 treble damages will apply to Justin depends on a finding, I believe, by the judge. No longer that the defamation claim is without merit, but it relies solely on whether or not Lively's claims are without merit.
right.
And that's completely different. They talk about some stuff about the Times. You and I touched on this a little bit earlier. I'm not going to get back into that.
Okay.
I'm on page 83. Yeah, he gets in all this stuff. There's no basis to infer anything other than that litigation was actually contemplated seriously and in good faith. The Wayfarer parties assert that the fact that Lively eschewed the administrative process and filed suit in federal court instead demonstrates that she did not file her claim in good faith. But the conclusion does not follow from the premise. It is a requirement under California law that before suing for any violation of California fair employment, a FEHA claim, a plaintiff must file a timely and sufficient administrative complaint with the CRD. The CRD then issues a right to sue notice. Thus, the fact that Lively chose to file in federal court rather than to continue in the administrative process does not deprive her of the benefit of that privilege.
The whole thing with the New York Times is like I don't think they really, and this is just obviously a layperson opinion, but I don't think that they particularly had a strong legal case against the New York Times,
Yeah.
just from the standpoint of someone who's not a lawyer. But it's just like when you look at the metadata and all that stuff that they included, and how like October 31st was like at the latest was when they started working on that. It feels so gross that they like contacted them at 9:47 p.m. the weekend before Christmas and was like, "We're publishing this tomorrow. Give us a statement." But they spent all this time on Lively's text, apparently going through thousands of pages of text messages and evidence, and they spent all that time over months, like kind of working on that to put out these stories about Justin Baldoni and the Wayfarer parties, and then they give them like 3 seconds to respond, and then they go live with it even before they said they were going to. So it's not like maybe not a legal issue, but again,
right.
from a human standpoint, it's absolute garbage behavior in my opinion. So
Maybe a shitty thing to do, but not illegal, I think is the conclusion, right?
Yeah.
But we've been saying that, or I've been saying that for, I don't know, ever since whenever I said it. I don't remember everything. The Wayfarer parties have not alleged that Sloan or Reynolds had acknowledged that the statements they were alleged to have made were false, or that they entertained serious doubts as to their truth. Because Baldoni is a public figure, he may own. Oh, this is talking about the sexual predator stuff, by the way. I didn't mean to gloss over this. A false accusation of sexual assault or similar sexual misconduct can support a defamation claim. And then they get into some other cases about how that's defined. And then they say that Wayfarer have not alleged that Sloan or Reynolds had knowledge that the statements that they were alleged to have made were false, meaning they didn't have any definitive knowledge that he was not a sexual predator.
Mm-hmm.
And if they didn't have that, then it was their First Amendment protected right to have the opinion that they had.
Sure.
And absent them having definitive proof that he was not a sexual predator, I guess that defeats the element of malice then, doesn't it?
Well, unless there was something in those thousands of pages of text messages that would show that somehow,
We'll see. Well, let's check this out. So he says,
Will we see though? Because this, I don't feel like this is really.
maybe not with respect to the cause of action related to, maybe not with respect to his causes of action against her,
Right.
but potentially as to the defense, his defense that against her claims. So whatever, if they find out definitive proof, and that Ryan Reynolds knew specifically that he was not a sexual predator, I don't even know how that would work, but let's just say that it was a thing, then he may then potentially bring that in as evidence of her maliciously filing an SH claim.
So you're saying you don't know how that would be. So say there's like a third party.
Yeah.
And that third party was either, they had their stuff subpoenaed or they voluntarily gave up the messages between her, Ryan, and Blake. And say those text messages showed that Blake and Ryan were planning to fuck with this guy in this way. Would that then, I don't know, be enough to show that?
The better example would be this. Let's just say that they find out through text message communications, through discovery, that Ryan Reynolds knew that the SH claims of his wife were bullshit.
Right.
Now you have malice. At least maybe certainly as to Lively's claims, potentially as to Reynolds, but that's not even a actionable claim right now because it's been dismissed. But that's how it still kind of gets in, because it then goes to the heart of Lively's claims at that point.
Okay.
Anyway, but you understand though, we're not going after Reynolds in that way anymore. We're going after the defense of these. I mean, to the extent that those causes of action are a thing, you still have those other two causes of action. They still may come up in the context of those causes of action. And certainly, if you find malicious, false claims that he knew were false, they can still be relevant in his other causes of action, including his defense, Baldoni's defense against Lively's claims. Does that make sense?
I think so.
When you say I think so, I feel like you didn't get it. I didn't do a good job of explaining it, but maybe I didn't. But that's ultimately how it would happen. He must plead the facts. Okay. He may only recover the statements were made with actual malice, meaning actual knowledge of falsehood or reckless disregard for the truth. He must plead facts demonstrating that the claims of actual malice is plausible. Although actual malice is a state of mind, it can be proved by circumstantial evidence. Direct or circumstantial must be pled. Evidence may include allegations of failure to investigate. They're going on and on. The actual malice standard is not satisfied merely through a showing of ill will. Thought that was important. And then ultimately, he gets an individual. As to Sloan, the amended complaint does not allege facts to support the inference that Sloan would have known that the sexual assault statement was false. There's no allegation that she was present when any contact between Lively and Baldoni occurred, nor are there allegations that she would have been told secondhand by Lively anything other than what Lively had alleged in the CRD. Sloan is not alleged to have reason to believe the Lively was untruthful. Moreover, once Sloan credited Lively's accounts of the facts, she also could have reasonably and not recklessly concluded that Baldoni had engaged in sexual assaults. In other words, she could have believed Blake. Could have. And the mere fact that that's a thing and Wayfair didn't plead anything against that is problematic. Now, the Wayfair parties argue that as a close associate of Lively, Sloan had a motive to defame Justin. And they go on to state more on that. But the amended complaint repeatedly alleges that Sloan was part of a conspiracy to spread knowing falsehoods. However, these allegations are entirely conclusory. In other words, you can't just say that without telling me how she did it. There's no factual allegations to support that Lively told Sloan that she was not sexually assaulted, or that Lively and Sloan agreed that Sloan would spread rumors of sexual assault despite knowing that they were false. As to Reynolds, Reynolds defamed Baldoni by telling a WME executive at the premiere of his movie that Baldoni was a sexual predator. However, as with Sloan, Reynolds was not present for any events during filming, and the amended complaint does not provide any reason he would have doubted Lively's version of events. In other words, what the court's saying is that it's awfully plausible that perhaps Ryan believed his wife. It's awfully plausible that Ryan called Justin a sexual predator because he believed that he was a sexual predator to his wife.
I mean, it's pretty hard to argue against that. Yeah.
And if you don't plead why that's not possible, that's problematic and fatal, as we've seen, to this cause of action. So, moving on, the Wayfarer parties argue that actual malice can be inferred from Reynolds' deep disdain for Baldoni and the fact that he was trying to convince WME to drop Baldoni when he made the sexual predator statements. But as noted above, actual malice refers to knowledge of falsity or recklessness with respect to truth rather than a motive to harm, and motive alone is insufficient to show actual malice. Reynolds may have disliked Baldoni, as the amended complaint suggests, but that does not mean that he knew Baldoni had not engaged in misconduct or was reckless with respect to whether he had engaged in misconduct. The facts alleged in the amended complaint, in fact, suggest an inference that Reynolds disliked Baldoni because he believed he did engage in misconduct towards Reynolds' wife. So when you read the judge's reasoning, does it make you less angry or at least understand it a little bit better?
I'm not angry about the judge's ruling. I'm angry that this lady is exploiting the system and exploiting, these organizations that are meant to protect people who actually went through some of the things that she's claiming to have gone through, and I don't believe that she did it. So
Yeah.
what the judge is saying, this is not what's getting under my skin at all.
Okay.
I think a lot of this makes sense to me. I try to take the emotion out of it when I'm reading this kind of stuff, and sometimes I just can't. But
Sure.
I don't think that this is not the upsetting part for me right here. It's the fact that people are going to take this as some sort of evidence that Justin actually did what he's accused of, and that she's now championing herself as like, oh, look at what I did for girls and women, when actually what she did was pretty disgraceful in my view.
Well, that's not even close to what this is. This is not a
No,
defense
definitely
of
not.
yeah,
It's just really hard because people are not gonna understand that,
right.
and, it's gonna obviously be, like, a really big deal today. Obviously, this is big news, and so and this is a heavily followed case, so it's just there's gonna be a lot of comments that are gonna put me off, so I'm just honestly happy that I'm gonna be on a plane for a while. So,
Yeah. I would hope.
yeah.
I mean, the logic is sound, and when you read the judge's reasoning, I can understand why he dismissed.
Mhm.
Just the way that he was thinking about this case is completely
Yeah.
different than how we've been thinking about this case. And a lot of that, I think, is just because we've been colored by, being content creators and
Yeah.
waves of anger and fear towards the lively side. And, you get affected by some of that. But just when you look at it without the color of PR, I can see where the claims are deficient. And so I don't think that the judge
Mhm.
is biased. I think the judge is applying the law.
Mhm.
I've seen no evidence to suggest that he's biased in this case. I am, however, a little bit surprised that he's not allowing them to amend those causes of action. And he gets into some of why that is. And as I wrap this up, I wanted to get into that portion of it that he read. I'm going to wrap this up in like 5 minutes. And so I'm not going to read like another 30 pages of this.
That's fine. I mean, as far as, like, some of this goes, the defamation claim, and like I said, I know that's a hard one to win. What was it saying? Like, if the amendment is going to be futile, then there's no point in allowing them to amend that. Is that kind of
Yeah, that's
what he
pretty
was
much what
saying?
he says. Here they talk about actual malice. The Wayfarer parties failed to allege that the Times made the statement with actual malice. The Wayfarer parties argue that actual malice is satisfied because the Times reporters reviewed private. This kind of gets to the thing you and I were talking about: private internal communications directly refuting the article. In response, the Times argues that the text messages contained in the article and CRD complaints, the authenticity of which have not been disputed by the Wayfarer parties, show that the Wayfarer parties did, in fact, engage in a smear campaign. Therefore, the issue is whether the documentary evidence of undisputed authenticity would plausibly indicate that the Times made the statement that the Wayfarer parties engaged in a smear campaign against Lively with a high degree of awareness of the statement's probable falsity. Even drawing all reasonable inferences in favor of the Wayfarer parties, the evidence does not support that the Times would have held such doubts. And he gets into some of the stuff. I'm almost towards the end. Yeah, I'm not going to read that. It's just more stuff. Yeah, I'm trying to get to the end. Tortious interference. He says that those are cool, but you have to. He said that there's issues with it, but I'm going to let them fix it.
Mm-hmm.
Same thing here. Leave to amend. Okay, here we go. The Wayfarer parties seek leave to amend their complaint to cure any pleading defects. Wayfarer parties' proposed amendments would, this is what they say they would do, cure impermissible group pleading, include additional facts relevant to choice of law, address the fair report privilege and actual malice as applicable to the New York Times, more fully incorporate the allegations in Exhibit A, amend allegations relevant to the civil extortion claims, add or amend the false light claim, add additional allegations of conspiracy to defame, specify that Lively's contract requires that her right to consult and approve on the film be exercised in a reasonable manner and not frustrates Wayfarer's production and development rights, and adequately allege Baldoni's contract with WME in support of the tortious interference with contract claim. Defendants oppose leave to amend on the grounds of futility and undue delay. And then they get into this stuff. However, it is well established that leave to amend a complaint need not be granted when amendment would be futile. The court will not grant leave to amend the majority of the Wayfarer parties' claims because amendment would be futile. The dismissal of the claims does not rest on technical pleading defects, and the Wayfarer parties have not made a showing that the complaint's defects can be cured. And I have to believe that Friedman, if there was a way to cure it, would have let it be known by now. Like, he's not been shy about writing letters to the judge about extortion and things like when he's had it. So I have to believe that if there was a way to fix it, Friedman was aware of the deficiencies. Maybe he didn't seek leave to amend because he knew that he wasn't going to be able to. I don't know. I don't want to speculate. I'm just stating that Friedman's a smart guy, a really good attorney. And if there was a way to cure it, he would have. And so that's the only takeaway I could possibly, the only conclusion I could possibly make with respect to that. They go on to say some other stuff. They're talking about Exhibit A. They're not going to get rid of Exhibit A. The court will grant leave to amend the claims for tortious interference of contract and breach of implied covenant or contract. The Wayfarer parties failed to plead the specific details of any contract between Baldoni and WME, but suggest in their briefing that this defect is easily curable, and so do it. As to 47.1, monetary sanctions. The court denies the motions without prejudice to renewal in accordance with the ruling here. The court has not ruled on whether Lively's statements were privileged under California Civil Code 47.1. If defendants choose to renew their motions, they shall fully brief the impact of this opinion, if any, as well as the issues raised in prior briefing. And here's where the court said, court has received several motions for leave for amicus briefs. We didn't rely on those to write this. In conclusion, the Wayfarer parties have leave to file a second amended complaint by June 23rd. That's like in a couple of weeks, amending only the allegations relevant to the claims of tortious interference and breach of implied covenants. Motions to strike are denied. Motions for fees and damages pursuant to New York civil rights law and California Civil Code 47.1 are denied without prejudice, subject to renewal by formal motion.
Well, her like little victory lap that she's doing right now, is super weird to me because, of course, it's saying like you didn't really consider the amicus briefs in that footnote there, and then also it's like they haven't ruled on whether or not that will apply or not. Not maybe that doesn't apply, but whether or not that's words are hard, man. Do you know what I'm saying?
Especially when you're sleep deprived and
I'm
on
so
vacation.
so sleepy.
Yeah,
Uh,
no. Look, her victory tour. I'm not gonna. I have no doubt that she doesn't understand what the judge wrote in those
yeah.
132 pages, the entirety of it. So she's gonna view it however she wants. She wants to do a victory lap. All I will say to that is that she will be judged on her own merits,
Mhm.
and her own merits are written in stone. This case might not be, but what she did is the only thing to do is to ferret it out through litigation. And Friedman and Justin Baldoni's ability to do just that have not been taken away by virtue of this ruling. That's the
Right.
most important takeaway from this motion I can offer to you. And so,
Yeah.
look, it's a defeat. It sucks, but it's not fatal. Um, I don't know, to make a sports analogy, it's the equivalent of like you're starting with really bad field position, but they didn't really score any points. They just made it harder for you to score points, is
Right.
all.
Cool.
So that's that.
You want to get through your star chats?
Holy shit, yes, I do. Thank you for that. Michelle says, Beal will drop suit and claim to be an advocate. That'd be rich.
I mean, I wouldn't rule that out.
I mean, I don't know. I don't know how Justin is feeling. I don't know how Friedman's team is feeling. I don't know if they'd let her just drop the case like that.
Nah.
We'll see. Maybe. I think maybe if she offers to do that, maybe they're more inclined to listen to offers for settlements. I will say that. I think that a settlement becomes much more likely if Baldoni can't bring claims for fraud and defamation. How much more likely? I don't know. VPan with 5 says, how is editing out text messages and publishing in New York Times not defamation? Well, because those would have been, if you're talking about that one article, all that they were reporting on was strictly the CRD, which was privileged. And if it's in a complaint, they had a right to report on what was in the complaint. That's why. The context of which is still up for debate. Those are tribal issues. But the reason why it's not defamation is specifically because those communications were privileged. And then we got this one. Now that they have B. Taylor's text messages, can they make it public?
Man, come on.
Could you interpret this question for me?
Now that they have Taylor's text messages, can they make it
Oh.
public without legal issues? You can do this. Come on.
I don't know which
You're worse than
messages
I
they're
am.
talking about.
What's happening here? Well, so like when the subpoena, they withdrew that.
Oh yeah, I wouldn't do that.
Yeah.
They would
So
have legal
she, I guess,
issues.
like voluntarily turned over
No,
information.
you specifically cannot do that. No.
Right.
Do not do that. KP says,
I feel like that's a bad idea. Yeah.
I think Friedman has something up his sleeve. He always knew he had to amend it. Now he's going to drop some bombs. Well, clock is ticking. They've been, if he's got something up his sleeve, it's best to, I guess at some point you got to show your cards.
Right.
So we've been doing a lot of speculating and wondering if Friedman is going to do anything. Now would be the time. I mean, now is not the time, just because of this ruling, whatever. As far as the Van Sham stuff, I've been waiting specifically for that. Haven't seen anything.
Yep.
I'm guessing that he's still on a fact-finding mission. My guess is that he's still trying to gain knowledge to support his claims for sanctions, whatever. But yeah, I can't imagine he doesn't have something up his sleeve. I just think that people are waiting on him to do something at this point.
Mm-hmm.
So we'll see what that's going to be. Teresa S. gifted one the court random Teresa S. This is for Lauren.
Yo,
You read this one, Lauren. I can't read right now.
she gifted a membership a couple times. Thank you, Teresa. I appreciate it. Looks like she did 3.
Yeah, she gave you
Very
3.
nice of you.
And then Valen Marchese with a 10.99 super sticker. Thank you, young lady. I don't know if that's for you or for Lauren, but thank you anyway. Anyway, I'm gonna wrap this up because it's been going on for an hour 45 minutes. Are you gonna do the Ask Two Lawyers thing?
We gotta be in 18 minutes, so I'm gonna take a 5-minute nap.
Well, let us you know what? I guess maybe we'll be joining the Ask Two Lawyers stream
Yeah,
right
I'll be
now
there.
and having a more intelligent discussion in my
Did they email you a link? If not, I'll send it to you.
yeah, just send it to me and then I'll have them check my email. I'll find out. But anyway, I love you all. I got to get ready. You guys take care.
Yep.
Bye-bye.